assets which need enforcement on residents outside the jurisdiction.
Just let me.
No, it's not possible.
Are you ready?
Yeah. Well, Mossad says he's happy.
All rise.
Morning.
Good morning all. We're here today for the hearing in the matter CFI 15/2014 before His Excellency Justice Omar Muhairi. The claimant is represented by Abdullah Al-Awali Advocates. Lead counsel is Musab Ali, assisted by Mohammed Musa. Defendant is represented by Al Tamimi and Co. Lead counsel is Zishan Dar, assisted by Tariq Shurain and Sarah Lee.
Good morning, and thank you for coming today. After reviewing the document and correspondence, I discovered that there is a kind of settlement going on behind the scene.
Unfortunately, there's been no progress on that front.
Okay.
Regrettably. So we are where we have been for some time now.
Then, as you are applicant, you can proceed.
I'm grateful, Your Honour. Your Honour, can I just check that there have been a series of updates to your bundle in the weeks running up to this particular hearing?
Yes.
And you'll be aware that this hearing was already adjourned once with the agreement of both parties. So with that in mind, can I just check that your bundle is, well, that we're both working from the same page, so to speak? Can I firstly check that you have, at tab 30, documents provided by the claimant's representative, not long ago? What you should have there,
Yeah.
tab 30, you should have a letter dated the 16th of February, and behind that letter you should also have the claimant's resident identity card,
Yeah.
a letter of undertaking, title deed,
Yeah.
and a board resolution, 2 witness statements.
Yes.
Can I invite Your Honour just to number those? The first page being page 307, for ease of reference, 308 through to 315.
Till 315, huh?
Yes.
The last page is 315, the witness statement.
Correct.
Yeah.
You should also have been handed up, or received yesterday, a document from the
Actually, I received it this morning.
You received this morning. That, can I suggest, you put that at page 316 of the bundle. So you should have the resignation letter at 316, and then the email from Altamedian Company, which was given to you this morning, requesting various information relating to that resignation letter at 317 of the bundle.
Okay.
Your Lordship, you also have some case law that I have provided this morning. What I've done, again, for convenience and ease of reference, is to provide you with an excerpt from the Civil Procedure Rules and the White Book, an original copy of which I have here. Thank you, I'm grateful. And there are two cases, also Harris and Wallace and Ayub and Muhairi, that I may need to refer to in due course. Your Honour will see in the skeleton argument that what we seek is an order for security for costs in the sum of $200,000 US. And you will see a copy of that draft order at tab 6 of the bundle.
Yes.
Your Lordship, the figure of 200,000 represents a third of the total estimated costs that the defendant says he is likely to incur from the start of the proceedings until the end. So we have been conservative in our request, going for much less than half and not more than a third. Your Lordship, in summary, what we say is that there is a real and urgent need to protect against the risk of being unable to enforce against any cost order the court subsequently makes.
And you refer me to Article 25?
I will in due course. But can I just summarise what we say is our position? In fact, if you prefer, we can refer to that.
So
now.
go ahead.
What we say is three things essentially. Firstly, the preconditions that require satisfaction are satisfied in this case. We say either the claimant is not normally and habitually resident in the UAE for a settled purpose. You'll note that the test under 25.101 of the RDC requires, as a first step, the court to be satisfied that one or more of the conditions or preconditions is satisfied, after which the judge can take into account all the circumstances of the case in determining whether or not it's just to make the order. We rely on two preconditions which we say are satisfied in this case. The first, that the claimant is resident out of the UAE. That's 25.1021. The second, we say, is 25.1026. The claimant has taken steps in relation to his assets that would make it difficult to enforce an order for costs against him. Now, I don't deal with that particular condition in this skeleton argument, but I will during the course of my submissions. In relation to the first question, whether the claimant is resident outside of the UAE, the claimant would have you take what they regard as the obvious and self-evident method of determining the question, namely, he's got a residence permit, he's therefore a resident within the UAE. Well, if that were the way in which the question ought to be approached, it would lead to an absurd result, because of course the claimant has had a residence permit at the same time for India, a United States passport, a Mozambican residence card, and a residence card for the UAE. So if that were to be the test, namely the existence of a resident card, then we would be unable to determine where in fact the claimant is in fact resident. So the question is not that simple. The question is one of fact, we say, and of degree. So the existence of a residence permit is not determinative of the issue at all, and the court ought to take into account a number of factors in determining the question of fact. Nationality, where the claimant holds residence permits for. Crucially, the reason for securing a residence permit. The length of stay within the jurisdiction as against the length of stay in multiple places outside of the jurisdiction. The location of his assets, the location of his principal business interests, and his family ties. What we say is when you consider all these factors in this case, and in particular the purpose for which we say he has secured a residence visa, the court, may I suggest, can quite nicely infer that he is not normally and habitually resident in the UAE for a settled and proper purpose. Your Honour will note that the provisions in the rules of the DIFC Courts 2004 as amended are identical in terms to those under the Civil Procedures rules as originally drafted. There is no material difference whatsoever in those rules. And so, can I invite your Lordship to defer to, if it's necessary to do so, to common law principles in interpreting the phrase resident. And you'll note in my skeleton argument I've referred to the decision of the House of Lords as it was then in R.B. Barnett, London Borough Council, ex parte Shah. It's a decision from 1983, but remains good law. It's referred to in the excerpt from the White Book that I asked you to consider. And the way in which the term resident has been interpreted is by giving it its ordinary and natural meaning. And so a person is ordinarily resident in a place if they habitually, normally reside lawfully in that place and for a settled purpose. We say the claimant doesn't normally reside in Dubai, in the UAE, that he's not habitually resident here, and that he's certainly not here for a settled purpose. So if I can deal with all those factors in turn, we know that the claimant is an American passport holder, and you can see a copy of his passport at tab 11, page 221 of the bundle. I won't trouble you with that now. And according to his legal representatives, he's been an American citizen for over 30 years, since 1984. He went to Cornell University, and he obtained a degree as a certified, or accreditation as a certified public accountant from Texas. He retains his American passport, and we understand that he has significant ties in the United States. I should stress at this point that ordinarily you would expect a respondent who faces an application for security for costs, especially an individual, to perhaps provide a witness statement, identifying where his assets are, saying what his movements have been, in order to establish that he's normally and habitually resident. We simply don't have any sworn statement from the claimant, or anything close to resembling that. He also has an Indian resident permit. And can I ask you just to look for a moment at paragraph 36 of the claimant's reply to our amended defence and counterclaim.
In which tab?
Which is tab 11. Sorry, forgive me, it's the respondent's, the claimant's evidence in answer to this application, and that's again tab 11. And in particular, page 149. So the document is a detailed document responding to our application. And at paragraph 36, the claimant says, or the claimant's representatives say, claimant is a USA citizen this is paragraph 36, since 1989, and a resident of India up to 2021. And that's important because this document was submitted on the 30th of December 2014, so not even 2 months ago. At that date, the claimant's own representatives regarded him as a resident of India. The terms are explicit there. And I submit that even if you can treat that concession with some degree of caution, which you can't, these are able representatives, it is highly indicative of the fact that the claimant is not resident within this jurisdiction. We know that the claimant has what is called a person of Indian origin card, which his representatives refer to in the context of his residence. They call it Exhibit 22 of paragraph 36, but you'll find the document in the same tab at page 222. This is effectively, for all intents and purposes, a residence permit for the claimant for India. And it doesn't expire until 2021. We know that the claimant was born in India, completed his law degree and his bachelor's there, and when he cancelled his visa on the 14th of August, beginning the 19th of August 2014, in the DIFC, the address that he provided to the DIFC authorities was an address in Mumbai, and that address, it transpires, is the registered business address of Adil Global and Sons. You can probably tell from the name of the business, but in any event, the company is owned by the claimant and his sons, and I've attached an extract, a web extract, in the additional documents that were provided to your Lordship 2 days ago, confirming that that is a registered business address. So again, it's worth just having a look at the document at tab 11, page 171. So you'll see in paragraph 3, or point 3, just to the right of the first whole punch at page 171. Your Honour, there are 2 sets of pagination. If you could focus on the pagination closest to the corner. 171, address outside the UAE, 9th floor, Brindaban, Car West, Dubai. When your Lordship looks at this bundle of documents that I'm holding up now, which I think you have, okay. This was an additional bundle of documents that was filed along with our skeleton argument.
Not yesterday or today?
Yesterday.
Yeah. This is the bunch of the passport copy and with the stamps. This is the one, or
no? That was from the claimant. This is a bundle of documents that was sent yesterday at 10:10 a.m. by email to the court with our skeleton argument and chronology. But I have a copy up there. It's perhaps worth just having a look at that.
yeah, I have it.
Great.
Mm-hmm.
And you'll see.
Company in Tanzania. This is the one.
Yes. Unfortunately, it's not paginated, and I apologise for that. But if you go towards the last page of that bundle, you'll see that you have the business address for Adil Global and Sons. It's a little bit difficult to read, but underneath where it says view phone number, it has the address 9th floor, Brindaban Building, 16th row, Car. I wonder whether your lordship has found that.
This is the one?
Yes. And just underneath where it says Adil Global and Sons, it says view phone number. And under there you have the business address in Mumbai, India, which is the same address provided by the claimant when he cancelled his visa in the DIFC on the 19th of August 2014. And importantly, that business is owned by the claimant and his sons. If your lordship looks at the document entitled Wild Bull Beverages Limited, the first page, this document was submitted.
Let's send this one.
This document was submitted by the claimant to the United Bank of Africa in order to secure a 7.1 million loan on June 20th, 2013. The reason I refer to it is it provides a nice summary of the claimant's history, his employment history, and in particular where he spent his time prior to coming to Dubai. Can I invite you just to read from where on the second page it says Mr. Asif Adil, that entire section there. It is clear from this passage that the claimant has worked for a significant period of time in India. And you'll recall, perhaps from the pleadings of the previous case management conference, that the claimant commenced working for the defendant on the 11th of August 2011. Sorry, 20th of August 2011. Prior to that, he worked for Diageo in India and John Distilleries as a vice chairman. And I'll return to that again in due course. But the point is he has strong ties in India and obviously a work permit. I then move to the third of the documents that relate to the claimant's true residence. Can I ask you to turn to page 240 of tab 11? Unfortunately, this is an unclear copy of the claimant's Mozambican residence permit. But what I do have, you'd be pleased to know, Your Honour, is a clear copy of it.
Muhammad?
Yes, if I could just pass it up. There's no dispute between the parties that this is a Mozambican residence permit in the name of the claimant. And it was valid between the 11th of October 2013 to the 11th of October 2014. It describes the claimant as the Director Geral. So I said that in French accent, it should be in Portuguese. But that means General Manager. And General Manager for Frontera LDA, which is a Mozambican registered company that manufactures alcoholic beverages, of which the claimant is a 25% shareholder and the General Manager, and was so between those two dates. And you'll recall that the defendant's case is that the claimant was dismissed on the 30th of June, whereas the claimant's case is that his employment terminated much later at the end of March 2014. So on his Mozambican residence card, reality, the claimant, if nothing else, has very strong ties in Mozambique and is normally and habitually resident there. It is significant to note that we say the claimant abandoned his offices, the defendant's offices, on the 30th of June 2013. And Frontera LDA is a company that is the subject of litigation between FDPL, the defendant's subsidiary PDEL, and the claimant in Mozambique. You may have noticed documents relating to that. I only mention it at this stage because it is the only evidence that we have, aside from the claimant's Lexus vehicle in Dubai, worth 130,000 dirhams, of the claimant's assets anywhere in the world. And we only know about it because of our subsidiary is in dispute and in litigation in the courts of Mozambique with the claimant. It's not because of any disclosure on his part. We wrote, still on the subject matter of the Mozambican residence permit, we wrote on the 2nd of February 2015 to the claimant, and we asked him whether he had retained a valid Mozambican residence permit in light of the fact that it had expired in October 2014. And can I just invite you to have a look at that letter, please, and the response that was received.
Which stuff?
Yes, it's it's tab 20, page 286. And we request various bits of information, proof of his ownership of any assets in the UAE or elsewhere, including bank statements. And importantly, at number 4, and I'll deal with the other requests in due course, but we say confirmation that your client has retained a valid residence permit for Mozambique and that he continues to also regard himself as a permanent resident of India as indicated in previous correspondence. The reference to permanent residence of India is obviously a reference in the claimant's evidence and response. And just pausing there for a moment, the residence permit and the continued renewal of the residence permit for Mozambique would be quite powerful evidence of the claimant's place of habitual residence. And we would say relevant and material to this application. The response of the respondent claimant is at tab 22 at page 289. Now, Your Lordship, I'm not showing you these documents to register some form of complaint. I'm highlighting the fact that the claimant is deliberately withholding information. You can see between the two hole punches where it says second, your questions enumerated 4 to 5 are irrelevant to the application at hand and hence merit no response. That's a direct reference to request 4, whether he's extended his Mozambican residence. We still don't have the answer to that question even today. In our view, there can be no doubt that the claimant, as a substantial shareholder and general manager of Frontera LDA, has compelling reasons to reside in Mozambique. It's the only place where we can say that the claimant holds substantial assets and business interests. But just yesterday, after the claimants, very soon after, a matter of hours after the claimants received this skeleton argument highlighting this fact, the court and ourselves received an email with an attachment. Your Lordship has a copy of that attachment. It is the alleged or purported resignation letter of the claimant from Frontera. Now, forgive me for being cynical But
which
you
is
might think
dated February 1st.
1st of February. Now, you might think that that document is a genuine document, provided by Mr. Asif Adil, frankly, to himself as a general manager, resigning his position in Frontline. Or you may take a different view, a more cynical view perhaps, and perhaps your cynicism may be better informed after I've gone through all the submissions that I need to make. But what I say about that document is this. The timing of its production is odd, to say the least, after we submit our skeleton argument, identifying the claimant's ties in Mozambique. It has to be considered in the context of the failure of the claimant, A, to provide a witness statement under oath, a sworn witness statement, and secondly, his failure to respond to the simple question, have you renewed your work permit or residence permit in Mozambique? We responded to that document by email, a copy of which you also had, requiring a number of different corroborative documents. But crucially, and perhaps the easiest document that could have been provided, which has not been provided, is the properties document of the soft copy, or the word copy of that document. That is a Word document, there's no dispute about that. That document would have been drafted by the claimant at some point. It will be on his computer. If his computer's in Mozambique, he can email it to himself in the UK, or to his solicitors. And all that would be required to do is to click on that document, to then click down on the properties box, and it will give you a screenshot of the date the document is created and the date that it is modified. And that would clear up and clarify that it's a genuine document, certainly created on a date that corresponds with the resignation. But again, that information has not been provided, and when I asked for that information, I was informed that it would not be possible to provide that information. The suggestion was that we requested that information too late in the day. With the greatest respect, that document only came to us yesterday. But I would ask you to draw adverse inferences from the silence of the claimant to respond to the request for that information, and the failure to provide us with an indication of whether he's extended his Mozambican residence permit. And then I turn to perhaps the most important feature in relation to the question of whether the claimant is normally and habitually resident in the UAE. And that's in relation to a UAE residence permit. That permit was cancelled at his request on the 19th of August 2014. I won't take you to that document now, it's not contentious. We filed our application.
And on that date, the claimant was under the company sponsorship, right?
Correct, Your Lordship. He was under the company sponsorship. And we have never refused to cancel his visa. If it's suggested that we have, that is completely wrong. Mr. Darga, who sits behind me, on receipt of that written request, which was first received on the 14th of August, responded immediately, cooperated with the claimant, arranged an appointment a matter of days later at the DIFC and cancelled his visa. That was the 19th of August 2014. We filed our application for security on the 9th of December 2014. We have this offer of employment from the claimant, which is dated the 23rd of December 2014. Can I invite you to look at that document at page 223 of the bundle tab 11?
The application?
No, it's not his application. It is the work, his employment contract.
Okay, and tab?
Tab 11, page 223. I've just tried to take this in chronological sequence.
What's wrong?
Yeah, so we filed our application on the 9th of December. This document is dated the 23rd of December. So 2 weeks after we filed our application, evidence in answer, 7 days later, on the 30th of December 2014, that's the evidence in answer to our application. And then, if you just turn now to page 283, can I just check that your Lordship has, at tab 17, page 282, which is a letter from the claimant. And over the page, it may not be paginated in your copy, you should have an employment entry permit.
Yes.
Can I ask you to mark that 283A? And then the next document, can you mark it 283B, please? That is the entry permit payment receipt made by the claimant. And if you look in the bottom left-hand corner, that payment was made on the 31st of December 2014 at 5:59 p.m. And over the page at 283, can I ask you to call that 283C? You can see the charges that were paid at 5:36 p.m. And it would appear, forgive my, I'm not totally familiar with the application process, but I'm led to believe that that is the point at which the application for the entry permit is completed. But that was done then on the 31st of December 2014. So it looks as though the claimant applied for his entry permit with a view to a residence permit on the back of this employment offer. Firstly, 2 weeks after we file our application, and either at the same time or the very next day after he files his evidence in response. And you may think, given that his visa was cancelled on the 19th of August 2014, that the timing of this application for a residence permit was a cynical attempt to outflank our application by establishing that he is or has a residence permit. It's important to bear in mind that when we first filed our application on the 9th of December 2014, it was accompanied by a witness statement of my colleague, Mr. Tariq Shrey. And it's worth just having a look at that for a moment. Just bear with me. And that is tab 8 of the bundle. And the relevant passage, sorry, forgive me, tab 7 of the bundle. What I want to refer you to is a reference to Mr. Shrey's statement that the claimant is a resident outside of the UAE. Yes, it's paragraph 10 on page 72. You say, here we say, because that was the situation at that time, the defendant respectfully submits that having satisfied one of the conditions set out in the RDC 25102 by reason of the claimant's residency outside the UAE, it is just in all the circumstances to make law. So what we're saying there is that he's not a resident, and therefore one of the preconditions is satisfied.
But again, this is a witness statement before.
Yes. And the reason I make this point is because this statement is dated the 9th of December. On receipt of that statement, it would appear that the claimant made an application for a residence permit.
But usually, according to the immigration rules and regulation, if the employee or any resident visa, his visa has cancelled, he has 1 month to leave or to arrange something like what the claimant did.
Well, what the claimant did is he secured employment on the 23rd of December after we filed our application. From the 30th of June 2013 until this point, the claimant his Mozambican residence card, which calls him a general manager, is dated up to the 10th of October 2014. We don't even know whether that's been continued. My point is here that even
But you are not sure he left the country after the cancellation, which happened on August 19, 2014.
Well, we cannot get that information, but we assume that that is the case. It may not be the case, but we can't get that information. And so that is precisely why, in a letter that I subsequently sent to the claimant's representative, which I'll show you in a moment, we expressly requested details of the claimant's travel, his length of stay, and the purpose of his stay from June the 30th, 2013 up till now. Haven't been provided with that information. And so the point about the UAE residence permit is that the timing of the application snaps of it being done deliberately in order to circumvent or outflank or get round the application that we were made. Because why on earth wasn't it made earlier? We haven't also been provided with any of the applications or job applications that the claimant has made whilst in the UAE. We simply get this offer letter that I would like to look at in more detail in a moment. But before I do that, it's worth just reminding ourselves of how the claimant has described himself as an experienced and accomplished global and liquor industry professional with over 30 years of experience. He was employed by PepsiCo as a finance director, McKinsey as a partner in their alcoholic beverages businesses. He's been an independent director of Shaw Wallace, which is India's second largest alcoholic beverage company. He was the managing director of Diageo in India. And your lordship will see from the documents that I've provided that Diageo is listed on the London Stock Exchange with a market cap of around $47 billion. He was vice chairman of John Distilleries, which turned over nearly 9 billion Indian rupees in 2011, which is around $130 billion. And then we turn now, just before that he was employed by the defendant, which is a substantial organisation with in excess of tens of millions of dollars of turnover. He has now gone from the heady heights of the board, so to speak, of Fortune 5 and blue chip companies to being employed, and I say this with the greatest respect, by what can only just be described as a small store in a marketplace selling ladies' handbags and glasses. And your lordship will see, if you haven't already, from the pictures that have been provided.
Which is the store in the Karamas.
Yeah.
This is what you want to say.
Yes. Your Honor will see from that store that it really is quite remarkable that he's come from the boardroom to what is a small store, which frankly is no larger than the size of a little market store, selling ladies' handbags. And perhaps when you look at those pictures, it's tab 27 of the parcel. Can I just ask you to look at those for a moment, Your Honor, please? This is a small store. There's no suggestion there's another outlet. And this store sells handbags. And your lordship may take a fairly cynical view of the nature of the goods that are being sold here. I think it's self-evident that these are counterfeit goods. We have no proof of that, but it is quite remarkable that a store of this size in the location that it is. Can I just say this? It's well known that in the Karama market, stores are selling counterfeit goods. And this is a classic case. This is the archetypal counterfeit goods store. It's littered with Mulberry, Michael Kors, and even Ted Baker unbelievable that the claimant purports to work for an organisation such as this in light of his previous history. The business has a total of 6 employees. Can I ask you to just look at tab 26 of the manual? This is a list of employees for rostering trading. There's the claimant, who's in sales, the accountant general, follow-up clerk, and 3 other sales assistants. The claimant used to work in organisations where he was responsible for and managed tens or dozens of employees. If you look at page 224 of tab 11, you'll see
200?
224 of tab 11. This is a translation provided by the claimant, incidentally, of the Ministry of Labour Work Permit application form. And you'll see from this, under classification, to the right of the first hole punch, right at the end, company classification, very small. That is the nature of this business that the claimant purports to work at. If you turn back a page to 223, we then come to the so-called contract of employment. And you'll see from this, the claimant is employed as a director of sales. You might think that that is a sophisticated title that doesn't really do justice to the role. His monthly remuneration is 80,000 dirhams. Now, that is a massive drop from the remuneration that he had whilst employed by the defendant. With the defendant, and it may be worth just looking at his contract of employment, just to compare the 2 contracts when you're considering the question of whether he's here for a genuine purpose. The contract of employment of the claimant is to be found at tab 2, page 20, where it starts. This is a detailed contract for the claimant as a managing director. You can see the scale of the remuneration here in comparison under point E at page 20. 600,000 per annum, which is about 45,000 dirhams, dollars per month, compared against the 80,000 dirhams he's allegedly receiving here. Incidentally, we haven't been provided with any payslips from the claimant from his new employment. But not only that, the claimant, under this contract, is entitled to a discretionary bonus. As part of the employment executive incentive scheme, and an equity grant which could represent up to $500,000 US dollars. So if the claimant has a good year, he gets about $1 million with FDPL. And you'll note from his claim that the claimant does in fact claim an additional $513,000 by way of an equity grant. So on the claimant's own case, his basic remuneration should have been $1 million a year. And I'd ask you to take that into account when considering whether this is employment for a settled purpose. Forgive me for a minute. I'm also reminded that the claimant, when one looks at the documents that I've provided, in particular his application to the United Bank of Africa for a loan, that he's spent his entire career in the alcoholic beverages industry, and even now, as we speak, as of today's date, he owns or is a substantial shareholding of an alcoholic beverages manufacturing plant in Mozambique. So you may think sudden switch, with the greatest respect, at this time in his life, is quite remarkable. From alcoholic beverages, Johnny Walker and the like, to plant foods into the market. It doesn't have a ring of truth in my submission about it at all. Well, we wrote to the claimant's representatives on the 15th of January, expressing our serious concerns about the genuineness of his employment. And that letter is at tab 16, page 227. See in the third paragraph, we express serious concerns about the genuineness of both the contract of employment and intention of your client to become a resident in the UAE. And that's really what this is all about. Is this a genuine intention to become a resident? And we highlight what is an odd situation. The contrast between former employment and alleged current employment. And we request a number of pieces of evidence in order to satisfy ourselves of the genuineness of this employment. And in response to that letter, on the 19th of January, that is at, sorry, in response to that letter, by a letter dated the 18th of January, which is at tab 282, sorry, tab 7, tab 16.
It's before me.
Forgive me, tab 17, 282. You can see the claimant's response. They say at the bottom of page 282, your allegations about the genuineness of our client's employment are unfounded, baseless, not meritorious of a response. Suffice it to say that all proper and legal procedures have been followed, and it is our client's prerogative to choose employment's terms thereof. Well, of course it is. But this court, in my submission, needs to consider whether or not, in the context of determining whether he is here for a settled purpose, that this is genuine. And the fact that he has been granted as a residence permit is not conclusive at all of that. And this court is entitled to find, notwithstanding the grant of the residence permit, having regard to the fundamental differences between his previous employment and this employment, that he is not here genuinely for a settled purpose. His true purpose in securing the residence fee that we say is to outflank our application. So that was their response. And again, on the 19th of January, when we make a further request, if you just look at tab 18 for a moment, Your Honor.
Tab 18?
Tab 18, page 284. This is the defendant being reasonable. We say, you failed to respond to our queries regarding the genuineness of your client's employment, and therefore his residence in the UAE. But we're prepared to agree to vacate a hearing to listen to the 22nd of January to enable you to furnish us with your client's residence permit first, and second, to satisfy us that your client is genuinely employed and wants to employ you. So there's two concerns there, not one. The response to that, again, is unfortunate. Over the page at 285. say that Mr. Adil is a consumer sector expert with specialisation in sales and marketing. He's previously worked in a variety of industries: soft drinks, snack foods, medical services, cosmetics, and alcohol beverages, amongst others. And that the business of rostrum trading is very fertile to tap into his expertise to expand into new avenues and geographies. You may think that there's no further that the claimant can take the little shop in rostrum that is rostrum trading in Karama Market. And if it's suggested that a store selling counterfeit goods is somehow going to be put on the global platform by Mr. Asif, none of this has a ring of truth in that submission. So in summary, we say that this is effectively a sham. And if you're not with me on that point, and you take the view that you don't want to look behind the residence visa, you can still take into account the features of this case in determining whether or not he is here for a settled purpose. And we say it can't be a settled purpose, but should be regarded as a settled purpose if what he's trying to do is to circumvent the application. Is this gentleman really going to continue to provide his services to rostrum trading, a completely different sector, from Karama Market, on the salary that he's on? We say not. You should also look at his length of stay and his movements. And on the 2nd of February, and this is at tab 20, and again I say this is crucial in determining whether he's normally and habitually resident here. In the last paragraph, we say, can you give us details of the countries visited by your client from the 30th of June 2013 to date, the duration of the stay and the purpose of the visit? And again, unfortunately, so what we want here is just an itemised statement from the claimant saying between the 1st of January to the 10th of January, Dubai, Mumbai, New York, etc. And from that we can decide, as a matter of fact, whether he normally resides in one jurisdiction or another. The response you have seen already. It's at tab 22. Between the two hole punches, they say it's irrelevant to the application at hand and merits no response. Another factor in determining whether he's normally and habitually resident here is whether he has ties by way of assets in the UAE. And at paragraph 4 of the skeleton, I make the point that the claimant has failed to provide a statement of means saying whether or not he has any assets or means of paying a subsequent cost to it. The only information, or the only proof of ownership provided is at tab 15 of the bundle. The claimant says at page 273, third, the claimant denies the allegation that he owns no assets in the UAE. The claimant owns a Toyota Lexus vehicle, 2013, valued at more than 130,000 dirhams, in addition to having a bank account in one of the leading UAE's branches. So that was in response to the letter before that, in which we request, or have requested, bank statements and proof of ownership. And what we got was a vehicle license plate, which is not in the bundle, but it's not disputed that that was provided for the Lexus. And a photocopy of a debit card from Mashrek Bank. But we didn't get any further information or proof of evidence of any of his assets. And if you look at tab 17, page 283, you'll see the only evidence of property that we have that the claimant owned in Dubai is in the last tab, Your Honour, at page 312. And you'll see that relates to his wife's property. This is Padma Asif Adil. And that Mr. Adil transferred that property to her on the 10th of March 2013. Now, that will become relevant to point 6 of section 102, sorry, 25.102 of due course. But all I'm doing here is making the point that he's failed to provide evidence of any of his assets anywhere in the world, aside from a car in Dubai. And we know that he has a substantial asset in Mozambique. And that's all the information that we have. He has said in his evidence in answer that his wife and 2 children own 5 flats in Dubai. They are in the names of those individuals. You may think that for a man of Mr. Asif's age and gravitas, with his employment history, to not be able to provide proof of ownership of any assets anywhere in the world, save for a Lexus motor vehicle, is quite remarkable. What is even more remarkable, perhaps, or not so, is the fact that the properties which may have been purchased by Mr. Adil appear to now be in the names of his family. And you may think that that is typical of somebody who is an international businessman and is making himself judgment-proof against litigation against him in this jurisdiction and or in other jurisdictions. But that remains a fact. No assets in his name. I come then to the question of recognition and enforcement, which is the third limb or reason why the court ought to exercise its discretion in favour of granting the order. As I said, all we know of is the asset in Mozambique, which is substantial. And what I would invite you to do is to consider the witness statement of Mr. Alfiado Pascal, a senior associate at a leading Mozambican law firm, which is at tab 9. And was submitted as part of our application. He makes 3 points in summary. The first is that there is no bilateral agreement or protocol between the UAE and Mozambique. And your Lordship will know that notwithstanding there may be legislative machinery allowing for the enforcement of foreign judgments in countries, that is not really determinative of the issue. What assists in recognition and enforcement is bilateral agreements or protocols. Courts in various jurisdictions are reluctant to enforce or loath to enforce and recognise in the absence of such protocols. I don't need to tell you that. The second point that he makes, Mr. Pascal, in summary, is that given that there are concurrent proceedings afoot in Mozambique at the moment between a subsidiary of the defendant and the claimant, where there are overlapping factual issues, it is open to the claimant, in the event that an award of costs is made against him in favour of the defendant, to resist the enforcement of that award in the Mozambican courts on the grounds that the Mozambican courts do not, forgive me, that there were concurrent proceedings pending in the Mozambican court, and that is one of the get-out clauses, one of the grounds of resisting costs award or any judgment that sought to be enforced under the Mozambican Mozambican Code of Civil Procedure. He sets that out in his statement. In addition to that, if a foreign judgment, that is a judgment of the DISC court, conflicts with a prior Mozambican judgment, that's another ground for resisting enforcement. So if this court makes a factual finding as to whether or not the claimant failed to transfer shares as directed to do to the subsidiary, whereas the court in Mozambique takes a different view, that would be grounds for resisting enforcement of the order. So he's highlighted those legal impediments. And lastly then, he goes on to deal very nicely with the likelihood of enforcement in Mozambique having regard to the practical impediments. He says the process is lengthy and it is cumbersome. And your Lordship will note from the RDC that what is required in any application in support of the security for costs is evidence and or a statement highlighting the difficulty of enforcement in a foreign jurisdiction. And that's precisely what we've done through the statement of Mr. Tarek Shrey and through the statement of Mr. Pascal. The claimants too have provided a witness statement. And it's just worth looking at that for a moment, because it doesn't really deal with the question or the difficulties and the conclusions reached by our expert. That document is at page 241, tab 11, 241. In the first 4 paragraphs, he says who he is and what he does and why he's providing this statement. In paragraph 5, he provides evidence of the judgment of a Mozambican court in relation to proceedings brought by our subsidiary. That's not relevant to the question of recognition and enforcement. In paragraph 7, he deals with another application for an injunction made by our subsidiary, which was unsuccessful. Again, he doesn't deal with enforcement or recognition. And then in paragraph 9, he simply says, in my opinion, despite the absence of any bilateral agreement or protocol, it is possible that any judgment issued by the court can be enforced in Mozambique, subject to legalization. He uses the word, it is possible. He doesn't deal with the probability of enforcement, doesn't deal with the likelihood of enforcement, and doesn't deal with any of the impediments highlighted by Mr. Pascal. We don't disagree that it is possible to enforce, but that's not the test. The court has to be satisfied that there is difficulty in enforcement, and we say that the unchallenged statement of Mr. Pascal makes that evidently clear. And then at paragraph 10, he switches back into dealing with the dispute between our subsidiary and the claimant in Mozambique. And then at paragraph 11, he says, there are several examples of foreign judgments being enforced in Mozambique. It is pertinent to note that despite the conclusion of Mr. Pascal regarding delays in proceedings before the Mozambican Civil Court, Project Development and Engineering Limited, this is the subsidiary, has within a period of 6 months had 2 judgments including appeals issued against them. He's missed the point completely. We're talking about the enforcement of a judgment from Dubai or anywhere else in the world in Mozambique. The enforcement of a foreign judgment. I'm not talking about the enforcement of domestic judgments in Mozambique, for which there's a completely different procedure. Mr. Pascal's evidence is that it is the Supreme Court that deals with the enforcement of foreign judgments, that there are only 10 judges, and that the procedure is very slow. He also remarks about the legal impediments and challenges that can be brought on jurisdictional grounds, particularly in relation to costs. It's not dealt with by Mr. Dyer, so I would invite you, if there is a conflict of evidence, which we say there isn't on the expert's report, to prefer the statement of Mr. Pascal on the question of enforcement. So that deals with the points that I've made in relation to normal are all factors in favour of the court exercising its discretion to make an order for security. I said earlier on that I haven't dealt with an important matter in our skeleton argument. I should deal with that now. One of the preconditions, Your Lordship, under RDC 25 is 25.1026. The claimant has taken steps in relation to his assets that would make it difficult to enforce an order for costs against him. Now, the first point I would make is this. It doesn't say here that what is required to be shown is that the claimant has taken steps in relation to his assets with the intention of making it more difficult to enforce a cost order against him.
But here you're talking about burden of proof, right?
No. Here they're talking about... So if Your Lordship follows the provisions, the first thing we have to do under provision 25.1011 is to satisfy you that one or more of the conditions below, i.e. 1 to 6, applies. We say 1 applies. I'm now also going to persuade you that 6 also applies. If you think either of those two applies, you then go on to exercise your discretion, looking at all the circumstances of the case to decide whether or not it's just to make a security for costs. And the first point I dealt with was residency, whether he's normally and habitually resident in the UAE. I referred you to his nationality, the 2 different residence permits, the difference between the old job and the new job, and whether there's a settled intention, as well as the timing of the application. What I now want to do is to also deal with whether the claimant has taken steps in relation to his assets that would make it difficult to enforce an order for costs against him. And it's important to bear this in mind. People often...
Which is what I'm saying, the burden of proof from the claimant to prove there is an asset. This is what I'm saying.
Forgive me, I misunderstood you. Well, we say he has no assets or has provided no proof of ownership of any assets other than the car. We also say the only asset that he did have in Dubai or anywhere in the world is a flat that he transferred to his wife's name in March 2013. And lastly, he has a Mozambique company of which he is a shareholder, and you can see the difficulties we would have in enforcing the award there. But dealing with the narrow point about whether he's taken steps to make it difficult to enforce an order for costs against him, we say the transferring of his property to his wife is such a step. Now I know that my learned friend will jump up and say, well, hang on a minute, that was done in March 2013, before litigation was even contemplated. That's not the test at all. In fact, the case law is very, very clear on this point. Can I invite you just to look at the excerpt from the civil procedure rules that I handed up as a starting point. So, it's the second page, condition G. Does your Lordship have that?
I think not this one.
Yes, so the second page, I think, yeah, it's condition G. And condition G is the equivalent of condition 6 under the DIFC Court Rules 2004. They're in identical terms. In fact, I have them here. They say the claimant has taken steps in relation to his assets that would make it difficult to enforce an order for costs against him. That's the CPR. It's identical to the RDC. And this paragraph sums up the case law. And what it says here, if you read the second paragraph, the purpose of condition G is to prevent injustice to a defendant where the assets available to enforce any order for costs they obtain have been or are being put beyond the reach of enforcement. The steps taken may be the dissipation of assets, of course, once litigation starts, if the claimant sold his car and realised the value, that would be dissipation. Or their transfer overseas or into the names of third parties, or their transfer or removal to places unknown to the defendant. The defendant, and this is the important part, is not required to show that the steps were taken with the specific intention of defeating enforcement, or that the steps were taken during the litigation or in contemplation of it. And that's Harris and Wallace. Now this is really important because the intention of the claimant in March 2013 is irrelevant. And can I take your lordship, please, to that case, Harris and Wallace number 2. Yes. You'll see that what I've done is I've put a case summary.
First stage?
Yes, it's Harris and Wallace number 2, Chancery Division, 10th of March 2006. And in this case, the appellant appealed against an order requiring him to provide security for the costs of the respondent. And essentially what he was saying is that firstly, a party had failed to provide particulars of his assets, he didn't disclose his assets, and then in addition to that, a debt that the claimant had assigned to a third party before commencement of litigation should not have been taken into account in deciding to grant security for costs. And you can see the decision in summary here. It's in the bottom paragraph. Held, dismissing the appeals. A security for costs order could not be made unless a court was satisfied that it was just to do so. It was not necessary to imply a temporal limitation into 25132, as it could apply to a person who some years before had taken steps in relation to his assets to make himself judgment-proof. When contrasting the wording of that section, which contained the words "with a view to," with that of the current section, which is the equivalent to the RDC, which omitted these words, it was clear that the conspicuous omission of those words in condition G, we can call it condition 6 here, meant that it was impossible to avoid the inference that the omission had been done deliberately to exclude any mental element on the part of the claimant taking steps as to his assets. So you don't need to be satisfied that the claimant deliberately transferred assets to his wife's name to put them beyond our reach in this litigation at all. You simply have to look at the situation objectively and ask yourself the question, is the step that he took in March 2013, does the step that he took in March 2013 make it more difficult for us to enforce any costs award in our favour? And the answer to that question is self-evidently yes. And I just want to highlight at page 4 of the judgment, 4 of 10, in the top right-hand corner, what the judge, in fact, says, Sir Francis Ferris, just above paragraph 11.
You're talking about Harris and Wood?
Yeah. Just before, on page 4 of 10.
I have page 4 at the last. 4 of 10, okay.
Yeah. He refers and confirms a dicta, a judgment in a previous case, where the judge says, just above paragraph 11, I myself do not see the need for implying anything of that nature into the terms of the rule. I do not see why it should not apply and be intended to apply to a person who, some years ago, had taken steps with his assets in order to make himself judgment-proof, and then have later taken advantage of that judgment-proofing by bringing proceedings. And then over the page at page 5, they highlight the 3 steps that you need to consider in dealing with RDC 25102. or the CPR equivalent, the claimant must have taken steps. The steps must have been taken in relation to his assets. The steps must be steps which would make it difficult to enforce an order for costs against him. Well, all three of those limbs are satisfied in this case. And then over the page, just to put the matter beyond argument, at paragraph 16, he deals with the facts. He says, he refers to this previous case of Ayoun and Bakr. And in that case, a Lebanese businessman who resided in Australia, had moved from Athens to Australia and then to England, and on leaving Australia, he had sold his home there, only to use the proceeds to buy a new home in London and to partly finance his business. So no intention there, no litigation on the horizon. And what is said at paragraph 16 in relation to that case is that the sale of the Australian property and the intended use of the proceeds, in particular the use of part of them to provide capital for Mr. Ayoun's business, would make it difficult to enforce an order for costs against him. And he ordered that Mr. Ayoun should give security. So that puts the case in its factual context. And then at page 8 of 10, he deals with the arguments that are made by opposing counsel. And just in the middle of the top paragraph, starting moreover, he says that conclusion is reinforced by the fact that when paragraph G, and you can substitute the number 6 for G, was introduced, it conspicuously omitted the words with a view to, which were suggested in the consultation paper and which are present in paragraph D. I find it impossible to avoid the inference that the omission of these words was done deliberately in order to exclude the mental element which Mr. Warwick contends. And Mr. Warwick was saying you have to show that this was done deliberately to put the assets beyond the reach of any court order. And the judge says, no, you don't need to show that at all. And he also indicated that there was no requirement to show that you should impose a time limit on how far back the court can go. And looking at the transfer of assets before it concludes that there's been, or that transfer would cause difficulty to somebody who's favour the security for costs order was made. Let me just repeat what I'm saying again. I perhaps haven't made it clear. The argument in this case, Harrison Wallace, was that, well, do we look at a transfer of assets 10 years ago as well, before any litigation commenced, or do we impose a time limit? And the judge says, no, there's no time limit. If a transfer, in all the circumstances of the case, makes it more difficult to enforce costs, then that is the position, and that needs to be taken into account. So, if you're not with me on the question of whether the claimant is normally and habitually resident in the UAE, we say position 6 is, in fact, self-evidently satisfied, and it's not even disputed that there was a transfer of the asset in his wife's name. And then the other factors that come into play, we say, provide a compelling case for ordering security for costs. They would be difficulty in enforcement against assets in Mozambique, the absence of proof of any assets from the claimant's safe at Scar, and the fact that the claimant in our submission, in reacting to our application in the way that he has acted in a manner that is questionable and without probity. But my principal submission, Your Lordship, is that he's not normally and habitually resident in the UAE. There were just 2 further points that the claimant deals with. He says that I ought to deal with, that the claimant's wife's undertaking, which you've seen in tab 13
as a solution to withdraw this application. This is how they offer it, right?
Yes, what they said is that Mrs. Adil will undertake to pay the costs of incurred in the event that the costs were made in favour of the defendant. But the problem with that is that it is an undertaking made by a third party to another party with no consideration. And if Miss Adil decides not to honour that undertaking, if you want to call it contractual undertaking, we would have to sue her and obviously serve her wherever she is normally and habitually resident. We don't know the answer to that question either. We would have to wait for judgment on the claim in relation to the undertaking.
But what do you think about the Article 25(103)?
Yes, we dealt with that in our letter, and it's important that you've raised that, because in order for this to apply, the defendant has to satisfy one of the conditions in the rule below 25.104. And the conditions are that the person, that is Miss Adil, has to assign the right to the claim to the claimant. And with a view to avoiding the possibility of a cost order being made against him, he effectively has to become a nominal claimant, the true claimant then being his wife. And we identified that possibility in our letter. If you just have a look at tab 14. So, if you look at this is the response to their undertaking offer. And just to the right of the second hole punch, we make the point that Miss Adil is not a party to these proceedings. The court cannot make an order against her for the payment of costs, because of course the undertaking is a contractual obligation to us, not to the court. In the event that the costs were awarded against the claimant and Mrs. Adil failed to make payment, our client would be required to bring a claim against her first before we go on and go on. But then in the next paragraph we say RDC 25.97 to 25.102 anticipates security for costs being made against the claimant and not, as is being proposed, the claimant's spouse. It is open to you to pursue the provisions set out in RDC 25.103 to 104. Those are the provisions that you've just identified, Your Lordship. Namely the provisions which deal with security for costs other than from the claimant. Should your client be seeking to take that approach, we advise him to do so as a matter of urgency and in advance of the up-and-coming hearing. Well, that was never done. That proposal was rejected, and it was open to the claimant to do so. We also say that we note that Mrs. Adil has 1 million dirhams in her bank account. We therefore suggest that she loans the claimant the sum of $200,000 US to enable him to make a payment into court. It's a simple solution that was offered. We gave them the option: assign the claim to your wife, fulfill the provisions of 25.104, or alternatively take a loan from your wife. Again, the response to that was less than satisfactory. It's at tab 15. And what it says in the last paragraph, in the last line, in addition, we do not believe that RDCs 25.103 and 104 apply to the claimant's case. Well, of course they won't apply. You have to make them apply by assigning the right. And unfortunately, the assertion is made that the proposed undertaking was to be made in court and based on which a consent order was supposed to be issued by the court's registry. But there's no mechanism in the RDC for a third party to provide an undertaking to the court. The undertaking is by one private individual to another private individual. the beneficiary can enforce by bringing a claim in the event that the undertaking is breached. What would be the purpose of having the security for cost regime if, as a substitute, or an undertaking was regarded as a valid and equivalent substitute, if in order to enforce it you have to sue, get a judgment, and then enforce again? It makes the whole system pointless then. And that's what we identified in our letters, and that's why we regarded the offer as being wholly inadequate. And frankly,
and do you think the figure or the amount, this is one of the reasons? To reach a settlement at the first stage? I'm talking about the security cost.
Yes, of course. It's never been suggested that the claimant doesn't have access to money. The letters that we've received have said, and you can see the letter, that the claimant and his wife have substantial assets, and that his wife has the phrase is 1 million dirhams in liquid funds in her bank account, and property is worth, I quote, 14 million dirhams. So that's never been the suggestion that the money is a problem. If that was the suggestion, they could have made a counter-offer in those terms at an early stage, in open correspondence, but they haven't done so.
In conclusion?
So, in conclusion, Your Lordship, I invite you to find that we engage preconditions 1 and 6 of 25.102, and once we do that, all the circumstances that I've identified to you make a compelling case that it is just to make an order in order to protect the defendants from the risk that a costs order will not be met in the event of success. I know you've asked me to sum up, and I know I've been a while, but there is just one other issue that I ought to deal with, and that is the claimant's suggestion in the skeleton argument that this is the correct forum for the court to undertake an examination of the merits of this case in order to determine whether or not security for cost should be granted. And I would refer Your Lordship to RDC 25.110 in that respect. It's abundantly clear that the court strongly discourages investigation of the merits of the case on an application for security. That's the first point. So it's an uphill struggle for the claimants to convince this court that that is what you should do. Only in cases where it can be shown without detailed investigation of evidence or law that the claim is certain or almost certain to succeed or fail will the merits be taken into consideration. I know, because he said so in his skeleton argument, that Mr. Ali proposes to invite you to consider the evidence in this matter. He specifically asked you to consider a board resolution, which you may have seen already in the bundle, and I'll take you to that now. But before I do that, Your Lordship, you remember that the principal issue in this case is whether the claimant was terminated on the 30th of June 2013, or whether his employment came to an end at the end of March 2014, following his resignation. We say 30th of June 2013. He says there is an email that confirms that we said to Chairman that he wasn't dismissed or orally terminated on the 30th of June. And he relies on that as an addition on our part. But you will have seen already, I've referred to it in my skeleton, there's an email that is equally forceful in support of the defendant's case. On the 3rd of July 2014 at 12:20 a.m., and the existence of this document is not in dispute, the claimant sent the third party an email expressly stating, I have left Suresh's company and now working independently. Now, 3 days after we say he was terminated, there is a clear conflict of evidence between the board resolution or any other document and the document that I've relied on. In order to resolve what is clearly, on any case, a direct conflict, you defence will fail or the claim will succeed. And in any event, your Lordship will have seen that it isn't just the question of dismissal or termination that's an issue. The claimant, we say, in any event, even if you decide the claimant's employment is terminated in March, or came to an end at the end of March 2014, he's not entitled to any due salary because he abandoned his position of work, excuse me, on the 30th of June 2013. And we say that at tab 3, page 48 of the bundle, in our defence and counterclaim. And we say that there's a common law principle on which we can rely that enables a court to decide not to award any compensation to a claimant in an employment matter that abandons his position and fails to satisfy his contractual obligations, even though the contract has not at that stage been formally terminated. So that is a question of law. It's also a question of fact. The court will have to consider whether he committed these acts of misconduct, whether he abandoned his position and went off to work for Frontline LDA in Mozambique. So it cannot be said that the claim that the defence is certain or almost certain to fail. In addition to that, the claimant brings a claim for $513,000 in respect of an equity grant, which he said is entitled to under his contract of employment. That is at tab 2 and page 13 of the bundle. Sorry, it is in fact tab 2, page 8 of the bundle. The claimant says that paragraph 15A that he's entitled to an equity grant of $500,000. That's half his claim. And that at paragraph C, he's still entitled to $513,888 US dollars. And we have said in our response that an equity grant is a grant of shares. So the relief sought by the claimant there is in fact misconceived. He's entitled to payment, he's entitled to an equity grant, if at all, on his own case. So for all those reasons, can I invite you not even to start down the road or up the mountain, so to speak, of considering whether or not this claim is certain, this defence is certain or almost certain to fail. But those are the points that I wanted to deal with in opening submissions, my Lord, unless I can assist you with any other questions that you may have at this stage.
So far, thank you. Unless the claimant counsel raise some issue, we'll discuss it. Please, Mr.
This is Somali from Rural Awali Advocates, and I will have the pleasure today to argue on behalf of the claimant for Your Honor. First of all, as a brief introduction from the claimant's side regarding this application, I have to say that the claimant was actually employed by the defendant on 20 August 2011 until the claimant has resigned on 28 November 2013 by giving a notice of period of 3 months starting from 3rd December 2013 up to 3rd March 2014. I invite you, Your Honor, to review tab 2, page 38, which is the letter of resignation of the claimant. At the last paragraph, it said that, the one before the last one, I await your instructions on the 3 months notice period as per employment contract. Lastly, I request that my DIFC employment visa be cancelled expeditiously on payment of all arrears due. It is a claimant submission that page 38 tab 2. The defendant has recently, in his oral argument, confirmed that the claimant has never requested the cancellation of his employment visa until August 2014. So it was worth noting that. Based on such resignation, the defendant's director issued a board resolution on 10th of March 2014, by which they recognized the claimant's letter of resignation and decided after the end of notice period to inform the DIFC authority that the claimant's name shall be removed based on his resignation from the position of director and authorize a signatory from DIFC record. As a result of the defendant's failure to pay the claimant's employment benefits, the claimant after that filed his claim, his present claim, on 6 May 2014. Normal procedures have continued until 10th of August 2014, when the claimant sent the defendant a letter by which the claimant offered the defendant 2 options. I invite Your Honor to tab 11, page 168. In such letter, as the claimant's residence visa within the defendant under the sponsorship of the defendant was about to expire in August 2014, the claimants offered the defendant 2 options. After repeated requests before, he again offered 2 options: either to accept and proceed with the cancellation procedures of our client's residence visa, or to renew the visa in question, the residence in question, until the disposal of the main proceedings. The defendant, in reply, he chose to cancel the residence visa of the claimant, and after that, upon that cancellation, firstly, the claimant decided to apply for a free-zone UAE residence visa based on his family and mainly his spouse's substantial assets within the UAE, keeping in mind that it is a main purpose for the claimant to keep his residence within the UAE in order to manage his affairs and his own family affairs within the UAE. During this period, the claimant, an employment opportunity arose, and the claimant, instead of having a UAE residence visa based on his spouse's assets, to which he is entitled for sure to have, he preferred to have an employment residence visa based on the employment offer made to him by another etablishment and a commercial entity based in Dubai since 1992 in Dubai. So, as an introduction, it is not, and it is even common to have 2-3 months after a cancellation of your ex-residence visa in order to obtain a new job within the UAE. During that period, the period when the claimant didn't have his residence visa, he came to the UAE on a regular basis based on his USA citizenship based on a visit visa on the entry of the airports. So, on 23rd December, the claimant could finalize and agree on an employment offer to be appointed as a director of sales at restaurant trading. As such, normal procedures were taken by the new employer in order to issue the claimant's new residence visa. I invite Your Honor to tab 11, page 226. This is the company profile of restaurant trading, which shows that it is based in Dubai since 1992. Also, I invite Your Honor to tab 22, page 289, which is a letter from the claimant to the defendant on 5th February 2015, by which he attached the UAE residence visa stamped in his passport. And actually, the residence visa was not included in the bundle originally, so we have to insert it in the bundle. So I assume that you have it, Your Honor.
Yeah, I have.
Yes. Also, Your Honor, as per normal procedures, I invite you to review tab 30, page 309, in which it is self-evident that the claimant has obtained a resident identity card. So, upon the confirmation upon the visa was stamped in the claimant's passport on 22nd January 2015, the claimant went to India in order for medical checkup, which is regular for his condition. After that, directly, for only a few days in India, after that, directly went to Mozambique.
I'm sorry, but the claimant's representative is now giving evidence that we have sought for the last 4 weeks. Now, for the first time in court, evidence of the claimant's movements for some time, and in particular since he was granted, or since he got an offer of employment. I'm astonished that my colleague chooses this moment in time to present as facts the claimant's travel, length of stay, and movements, when he could have done it previously. I mean, it's shocking, frankly, that he's chosen to do that. We have no means of verifying this.
Okay. Let him finish and we'll come to your
I will address that while I'm doing my oral argument. But anyway, for facts that you are listing, that after that he went to Mozambique in order to wind up his affairs and resign from his position as a managing director of Frontera based on the resignation letter dated 1st of February, as I think, Your Honor, you have reviewed already. Accordingly, the claimant, after handing over his responsibilities in Mozambique, he then left on 13th February 2015 to Dubai and officially commenced his work for restaurant trading on 15th February 2015. After this brief introduction, we hope, and I think I will address all the concern of the defendant's legal representative. And I think we should firstly pay attention to two key questions in this application, which are about whether the claimant's residences in India or USA, by the way, affect his position or his confirmation that he's a habitual resident of UAE? And the second key question about the sham employment as alleged by the defendant. I have to deal with the first one about multiple residences and habitual residence of UAE. It is possible and even common in a global city and business hub of the Gulf, like Dubai, for an individual to be a resident of more than one country. The claimant actually takes the view that being a resident of more than one country does not in itself pose a risk of failure to enforce court order in UAE and does not pose an indication of non-habitual residence within the UAE. It is self-evident, Your Honor, that all UAE residents who obtain and who secure a residence visa are foreigners. They are not UAE citizens for sure. And as such, most of the UAE residents, if not all, for sure, maintain another residence in their home country. So if we adopted the situation that multiple residences in itself pose an indication that if a person holds multiple residences in UAE as a resident of UAE and a resident of another country, that this is in itself constitutes an indication that he is not a habitual resident of UAE. So we will have that most of the residents within the UAE will be in such a situation. This is first one. The second, that it is quite clear from the defendant's submission that the defendant avers that the claimant has lost his habitual residence as alleged within the UAE starting from 30 June 2013 based on the alleged abandonment of the claimant's work within the defendant. So I assume that this does mean that the defendant agrees that prior to 30 June 2014, the claimant was a habitual resident of UAE. During that period, the period before 30 June 2013, the claimant also standing as a USA citizen. The claimant standing as a resident of USA, as his home country for sure. And the claimant was obtaining a permission of residency within India since 2006 until 2021. So I think it is irrelevant to prove that the claimants being a foreigner or holding a residence, which is a normal effect for a person being born in India, that means that he is not a habitual resident of UAE. Indeed, Your Honor, the defendant implicitly admits that prior to 30 June 2014, my client, the claimant, continued as a habitual resident, while at the same time he continued as a USA citizen and as an Indian resident. So, turning to the Mozambican residence permit, which was obtained actually during the claimant's employment for the defendant, it is worth noting here that the issue of Mozambique and the issue of Frontera was actually a part of the claimant's arrangement, a part of the claimant's employment, an arrangement for the claimant's employment within the defendant at the time. I think it is undeniable that the defendant was fully aware of the issue of Frontera since 2012. And indeed, the issue of Frontera was actually originally a part of his claim, in his counterclaim to these proceedings. But after that, he opted to change the counterclaim and submitted his amended one. So, I invite you, Your Honor, in this regard, to review the new documents, which is entitled Wild Paul Beverage Limited, which is different from the bundle, which is submitted to prove the claimants being a top-ranked employee. In page number 3, which is mentioned down, page 1 of 28, it is mentioned that board and management team
Is headed by business plan?
yes, business plan. The last point, board and management team biography. Mr. Suresh and Mr. Asif. Mr. Suresh, who is the defendant's chairman, the one who verified the amended defense and counterclaim on behalf of the defendant, Mr. Asif and Mr. Naveen. If you will, a page period which is mentioned down number 12, the second page of the document. It is mentioned that Mr. Asif is an experienced and accomplished global and local industry professional with over 30 years of experience. He is currently the managing director of Frontline Development Partners, Dubai. He is also the managing director of Frontier LDA. Frontier LDA is the entity in Mozambique to which the claimant worked for a period of time as a managing director with the approval of the defendant itself. And when the claimant chose to apply for a new employment opportunity and his new employer was not agreeable for that for sure, so the claimant has simply resigned from that position directly after securing the UAE residence visa. Another issue, Your Honor, for the matter of habitual residence within the UAE, I invite Your Honor to tab 13, page 310, which is a sworn statement as given by the claimant's new employer. Tab 13, page 310. It is read as follows, that this is to certify that Mr. Asif, holder of USA passport, is currently employed with Rostrum Trading. He is attending office regularly as per the company rules. He is also attending the current business and also growing the business of the company in Dubai, UAE and other markets which require him to travel. This statement is being sworn by me, Mr. Shashikant Damodar, in my capacity as Accountant General in charge of administration of Rostrum Trading. This is another evidence of the habitual residence of my clients, the current habitual residence of the claimants within the UAE, after we drew the attention that being or holding other residences in our countries does not in itself pose an indication that the claimant is not a habitual resident of UAE. Beside that, I turn to the defendant's requests about some certain documents that he asked in order to be confident that the claimant is actually a UAE resident or a habitual resident of UAE. And on the letter dated 15 January 2015, the defendant side, which is under tab
17.
yes 17,
Page
and
2.
also it's 16 page 277 till 281, and another letter of the defendant's legal representative dated 5th of February 2015, which is under tab 22.
That's yours.
Yes. 4th of, it is 21. Yes. 4th of February.
22 is defendant letter.
Yes, the
21
defendant.
is your letter.
Yeah, 22. Page 287. And such letters, such two letters, the defendant has requested the claimant to produce some documents such as details of the countries visited by the claimant from 30 June 2013 to date, the duration of the stay, and the purpose of the visit. He asked also for a proof of ownership of any assets in the UAE or elsewhere. He asked also for statement of banking accounts in the UAE since 1st January 2014 to date. Actually, the claimant, and for sure he asked for other documents, and the claimant actually provided the defendant with some of the requested documents which the claimant considered reasonable in such application, such as a sworn statement which has been recently reviewed by Your Honor, such as passport stamps from 22nd August 2014 to date, to the date of the letter that we served such passport stamps. That passport stamps are under tab 17. Attached to tab 17, page number 282. This is the letter. I invite you, Your Honor.
Yes, it's before me.
Yes. The client, the defendant actually originally asked for the stamp of the claimant's passport, starting from 30 June, I assume, 30 June 2013 to date. But actually, 30th of August 2014, while the claimant was holding his residence in the defendant, under the defendant's sponsorship, he was using the e-gate. So we clarified that to the defendant, and they provided for passport stamps from 22nd August 2014, the date of cancellation of his residence visa. We provided also proof of some assets, ownership for the claimant within the UAE, such as vehicle and mushroom bank account. The claimant also has listed down a USA assets owned by him in USA and India in paragraph 39 of his evidence in answer.
And which tab?
This is under tab 11. Paragraph, sorry, Your Honor, it's 37.
No.
Tab 11,
And which page? Page number?
page 149.
Yeah. And which paragraph you said?
37, Your Honor.
Okay.
That which should be read as follows: that the claimant owns several assets in USA and India. In the USA, the claimant jointly owns with his spouse real estate at 51 High Meadow Lane, Pasking Ridge, New Jersey, and further asset. The claimant also stated that he owns liquid financial dollar assets worthy significantly amongst other financial assets, and that in India, the claimant owns jointly with his spouse real estate at 9th floor Brindleman. So, we have not been requested firstly to provide the ownership or the proof of ownership for such properties unless 4th of February under tab
But on the paragraph 37 statement, do you provide an evidence for that?
No, I'm coming to that point, Your Honor.
Just for a moment.
Yeah, let him.
Sorry.
That under tab 20, which is a letter dated from the defendant, dated 2nd of February 2015, page 286, he, for the first time, he asked for proof of the claimant's ownership of any assets in the UAE or elsewhere. The word elsewhere, it is the first time appears on his correspondences. At that time, actually, if Your Honor notes the evidence of this application, that it was adjourned firstly for, there was a hearing listed period to that letter, and it was adjourned based on the mutual agreement of both parties. And I invite Your Honor to our letter under tab 19, page 285. In such letter, page 285, we confirm in the last paragraph, which starts as second, we are in agreement to vacate the hearing listed for 22nd January 2015 for a period of 21 days to only furnish you with a copy of our client's residence visa stamped in his passport. Your Honor, in order to understand that paragraph,
Read the rest of it.
it is the last paragraph. Page 285. In order to understand why the claimant has emphasized and clearly stated that we agree to the adjournment in order to only furnish you with our clients, the claimant's residence visa stamped in his passport, I invite Your Honor to read tab 14, page 270. This is the defendant's letter in which he stated clearly that,
In which paragraph you read it?
yes, I'm coming, Your Honor. Yes, paragraph 4, which starts in sum,
From the below or
from the above,
Okay.
from the top. It is stated that in sum, until such time as the claimant secures a residence visa, the fundamental concerns which underlie this application remain. So based on that statement, we try to convince the defendant that my client, while he is entitled to have a free zone UAE residence visa with no issue to involve himself in any employment, but he chose to have an employment UAE residence visa, and we try to convince him that procedures are followed as normal, but he was, the defendant was totally wasn't totally aware of the normal procedure of issuance of onshore residence visa within the UAE. So we agreed, we offered and invited him to adjourn the first hearing of this application, which was listed on 22nd January 2015, in order to furnish him with that residence visa stamped in his passport. That's why when the defendant asked for many things under his letter, 2nd of February, which we just reviewed, page 286, we replied as agreed previously that we have adjourned the hearing in order to furnish the claimant's residence visa stamped in his passport. So it is in no way that the claimant were in failure to provide the defendant with proof of ownership of his USA assets, because it has been requested after a mutual agreement to provide him only with such residence stamped in his passport, which should undermine the concerns of this application, as he stated in his letter. Furthermore, we are here, Your Honor, it was for sure the claimant does not hold all his title deeds whenever he travels or whenever he goes, but we have here some photos of such assets, which...
This is really problematic, I'm afraid to say. I don't know why this keeps happening. My learned friend is well aware of the rules and procedures that apply in these courts. I'm at a loss to understand why he's chosen today to bring these at the very last moment, not even before we stepped into court, not even before you stepped into court, but now, after hearing my submissions for an hour and 15 minutes, and having been on his feet for the last 25 minutes, refuses to produce documents. Now, the difficulty with that, of course, is that we haven't had an opportunity to consider those documents. But more importantly, there comes a point in proceedings where one must say enough is enough. It's one thing to make unvalidated, unsubstantiated statements in open court as counsel without a shred of evidence to support them. It's quite another then to produce documents for this court. And I object, in the interest of justice, for the production of any further documents in this case. And I would invite your Lordship to exercise his supervisory inherent jurisdiction and to restrain the claimant from attempting to produce any further documents. It is simply too late.
Your Honor, I'm not submitting documents. I'm saying that I have some photos for the assets of the claimants in the USA. I'm not submitting anything.
Continue.
It's the same thing.
Yes.
It's the same thing.
Please.
Okay, continue.
I think the defendant's legal representative has a right to counter reply, so I just will finish my role around him and he can address his...
Just focus on the
Yes.
Article 25, 1 and 6.
Yes.
Actually, 25, 1021 and 102.6.
Point
Now still we are point...
Point one, the first conditions. So, I assume that the claimant is a habitual resident of the UAE. We offered more than enough documents to be produced, but I cannot produce such massive documents like details of the countries visited by the claimants from 30 June 2013 to date, the duration of the stay and the purpose of the visit, and statement bank accounts since 1st of January 2015. Those documents either privileged under the legal or ethical rules, or it indicates unreasonable burden to produce. And we have to draw the attention that there is another ongoing litigation between the claimant and the defendant subsidiary in Mozambique. So there is no trust, actually, between themselves to submit the whole such massive and gross document for the defendants. We don't know if it will be permitted to be used only in this proceedings or it might be used for another purpose. So the claimant produced the documents which he deems enough to prove his habitual residence within the UAE, which is his residence visa stamped in his passport which is his resident identity card, sworn statement from the new employer, and passport copy for entry and exit stamp starting from the cancellation of his visa. And in addition to that, the claimants believe that the defendant has misjudged reading some documents, because in the defendant's skeleton argument, paragraph 3.16, in paragraph 3.16, it is stated that the claimant hold an only temporarily resident permit in the UAE for not settled purpose. And it is for sure not temporary resident or temporary permit for residence. It is a residence visa, stamped in his passport, a resident identity card, finished. Something which is for sure for a settled purpose, which is the employment of his new employment. So that will push us for sure to consider his allegation of sham employment within restaurant trading, in order to cover the first condition of whether the claimant is a habitual and normally reside within the UAE or not. First of all, the claimant, Your Honor, objects to the inclusion of documents 27 and 28 of the bundle. 27 are photographs, and 28 is actually a business card of the new entity, the new employer's entity, restaurant trading. I assume, Your Honor, that you noticed under tab 30, page 308, we stated that in our letter dated 16 February, we stated that we object to the inclusion of documents numbers 27 and 28 of the application bundle. Our client strongly believes that the said documents were obtained by way of false representation, as more fully described in the witnesses' statements of Satish and Shashikant, the witnesses' statements attached to this letter. I refer, Your Honor, to such statements which clarify, as stated by those witnesses who are employees and representatives of restaurant trading, that there is a person who came to the entity, an establishment, and alleged that he's a lawyer from Labor Department. After that, he took a phone number of the director of the entity and phoned him, and also kept investigating about the claimant's employment within restaurant trading. And after that, they called that number back, they found it's Altaminium. So,
but the fact is, your client or the claimant is employee of this company.
Yes, but
and there is a resident visa, Emirates ID, prove that.
Yes.
And I think no need to discuss more than that. Move from this point.
Indeed, Your Honor. That's it. And this is in principle, because we felt that there is a possibility of procedural unfairness in this issue. But second point, it is a general rule, Your Honor, that the claimant has the burden of proving his allegations. However, the defendant, as we believe, submitted no evidences, but some certain photographs and other documents relating to a business entity, which is restaurant trading, based on which the defendant, as the claimant, believed, has imagined and speculated that the claimant's employment is sham. Based on what? Actually, we do not see something else but this photographs. These photographs means nothing. Your Honor, after we submitted the sworn statement of the new employer that the claimant has begun his new employment and attends on a regular basis, and he officially started his work within the restaurant since 15 February, and that the claimant's job within restaurant trading is not to sit across counter to sell piece by piece. The claimant's job within restaurant trading is to develop, is to build sales, is to explore new business opportunities, to bring large orders.
But again,
Yes.
On the Ministry of Labour, his title is salesman. How do you explain that?
For the issue of sales, it is only mentioned sales. I think so that it was.
What I believe, I can read Arabic, and
Yes.
Arabic
Yes.
says it's totally different how you explain.
For the employment offer that we agreed, I refer you reply, Your Honor, to tab 11, page 223.
Yeah, okay.
On such employment offer which has been agreed and accepted by Mr. Asif, the claimant, and his signature appears down, and accordingly constitute the contract of employment between the parties, it is mentioned clearly that you will be employed as a director of sales, and after that the remuneration of his employment. So the claimant is not familiar how it comes only sales on the residence visa and his passport, but that's what happened. And it might be because it is a small entity regarding the number of the employees that they only allowed that title, not as a director of sales. But that's what happened, and that's what has been officially issued from the authorities in the UAE. In this regard, the claimant believes that symbol does not mean sham. And he repeats again that symbol does not mean sham unless otherwise proved by conclusive evidences. And we have to take into account that why the claimant take himself to be involved in sham arrangement in order to secure a residence visa, while he is entitled to secure a residence visa based on his spouse's substantial assets within the UAE. So it is a question that have not been dealt with by the defendant up to date. And in this regard, regarding the small entity of restaurant, that they are only 6 employees, we draw the attention again that the defendant itself was a startup business with 0 employees when it employed the claimant. And when the claimant have left the defendant's work, it was only 6 to 7 employees. Does that make the claimant's employment within the defendant at that time sham? Because there are only 6 or 7 employees?
Just to confirm one important point here.
Yes.
Your client, he's a resident, UAE resident.
Yes.
Mozambique, permanent resident.
Not a permanent. We believe that other residences, whether in USA,
Okay.
whether in USA as his home country, or in India as being booked, or Mozambique as relative. I'm coming to this point.
Okay.
Yeah.
Again,
Yes.
he resident in Mozambique, UAE, and has a US nationality.
Yes.
And has an
Resident
Indian.
in India.
In Mozambique, yes. He originally secured his residence within India since 2006, and for sure his nationality from 1987. For Mozambican resident, that was in relation to his arrangement with Frontera, which was part of his employment within the defendant itself, and it was permitted and it was agreed. But he is no more an employee of Frontera as he resigned, and we confirm that through the letter of resignation,
Which I received it this morning.
Yes,
Was that a letter I received?
actually, for this issue, it is good to see that this is my statement as a legal representative, that I have obtained this document normally 2 weeks ago. It is no way has been created on a day before the hearing or 2 days. I have obtained these documents from 1 to 2 weeks ago, but we didn't submit it because it was never raised. The issue of Frontera or being an employee in Frontera in Mozambique, even in the application, in the witness statement, the first witness statement of Mr. Tariq Shway. So, after we, and especially that we resigned, the claimant resigned from his position in Frontera after securing and after his residence with restaurant trading went final. So he resigned and he submitted that to me after being submitted to Frontera for my information from a week to 2 weeks ago, but we didn't feel that it is necessary to submit it right now. We submitted and we furnished the claimant's residence visa in UAE as was agreed originally, and we believe that being a habitual resident in the UAE is enough to prove that this application should be withdrawn.
Okay, as a point one.
Yes.
Anything you want to add more? In regard 2510.
Yes.
21?
Only last point regarding sham employment, that we want to say that rostrum trading is actually very fertile to tap into the claimant's expertise in order to expand it into new avenues, new opportunities, new business, being an establishment based in Dubai from 1991. The claimant is a consumer sector expert with a specialization in sales, marketing. He worked in various industries such as soft drinks, snack foods, consumers, cosmetics. So it is for sure the activities authorized to restaurant trading in line with the claimant's line of expertise. This is
I think
for,
you had enough on the
yes,
first
for
one.
the issue. So
Let's go back to the number 6, or actually point 6.
yes, number 6. The claimant, the defendant, sorry, has only today, I think, or even referred to the application of RDC 25.102.6. He might refer to that in his skeleton argument and detailed that in the hearing today. And the claimant, the defendant, was reviewing with you, Your Honor, a precedent or a judgment, which I believe I should have a copy of that, because I don't have a legal authority.
It's referred to and summarised quite nicely in the excerpt from the white book that I handed up to you, that you have. But I'm happy to give you a copy of the
Yes.
case as well.
In such,
If you want to take my copy.
In fact, I've marked with a black marker.
Yes.
Excerpt.
the black.
Now we're going
Okay,
to refer
yes.
to the
For that condition,
authority, to the case.
my colleague
it's okay.
will
Go ahead.
review it to refer to a specific point which we heard, I assume. Our first reply to the allegation that RDC 25.102.6 applies, that the defendant submitted no evidence to prove that the claimant has taken steps in relation to his assets that would make it difficult to enforce an order for costs against him, but to his reference in the skeleton argument that the claimant has transferred a property to his spouse name on March 2013. And I draw the attention that such date is too much earlier than these proceedings at all. Such date is even prior to the alleged determination date of 30 June 2013. It's on March 2013. There were no dispute at all at that time. No official proceedings had been initiated. And I assume that making a transfer to his wife at such does not constitute an evidence that the claimant is transferring assets in order to avoid cost order, while there is no termination happened, even if, as per the allegation of the defendant himself. This is one. The second one, if the claimant wants to avoid cost orders and accordingly transferred property to his wife, why is currently offering an undertaking letter from his wife to pay the cost if being ordered for the favor of the defendant? If this is the case, so it is for sure that the claimant will not offer such undertaking from the same person to whom the property has been transferred. The third thing, that it is the claimant confirmation, and he confirmed that in his evidence and answer as we reviewed, that he still owns some assets in USA and India. So we believe in no way we should consider the situation at all. It is a transaction has been made in very earlier date, even prior to the alleged termination on 30 June, because it was on March 2013. The same person to whom the property was transferred to, we are offering, as a claimant, offering an undertaking from such person herself, which is his spouse, to undertake that she will pay.
But she's not a part of the case, right?
She's not a part of it. This is the second point regarding this undertaking. I will come to it in the factors and circumstances which should be weighed regarding this application. So, save to the issue that the claimant's wife is not a party to the proceedings, which I postponed to later stage in the oral argument, we believe that there is no way that the claimant has taken any steps in relation to his assets in order to avoid enforcement of any cost order, if any. So, we confirm that none of the conditions set out in RDC 25.102 applies to this application. And even if, to which we deny, we believe that having regard to all circumstances of the present case, that a security should not be granted, even if we adopted the situation that the claimant is not a habitual resident of UAE, which is a fact actually, proved by official and conclusive evidences, as previously set out. The first factor that I rely on is the claimant's is that the claimant's claim is certain or almost certain to succeed. Without detailed investigation, as recommended under the rules, Your Honor, it is the defendant's case as expressed by his first witness statement, that the claimant has been terminated for cause on 30 June 2013. Without detailed investigations, we provided two pieces of evidences, which is the board resolution under tab 30, page 313, which is stating that Mr. Asif Adil's name shall be removed as authorized signatory from HSBC Bank, as he has resigned from the position of director of the company via letter dated 28 November 2013. Such board resolution, Your Honor, as appears on the top, it has been resolved via telephonic meeting held on 10th March 2014. That was after the end of the notice period, as per the claimant's defense, that he resigned by a letter dated 28 November 13, by giving 3 months as a notice period starting from 3rd December 2013. This is the first conclusive evidence. The second one, which I invite you, Your Honor, to read, is under tab 11, page 236 to 237. Yes. Sorry, Your Honor, it is 233 until 235. Tab 11, page 233. Paragraph A, which starts that despite the company, which is Frontline, being in continuous communication with you in emails, it has never terminated your services either orally or otherwise. That clear statement, without detailed investigations in the whole concept of that email, refute clearly the defendant's case, which they expressed in their witness statement, that the claimant, Mr. Asif, was terminated for cause orally on 30 June 2013. In this regard, we draw the attention that in their skeleton argument, the defendant changed his storyline from summary termination to abandonment of work on 30 June 2013. But he didn't focus on that issue. So, we believe that based on these two conclusive evidence, it is for sure their statement of case, their statement that the defendant's case that Mr. Asif was terminated at Ilya Bit is not correct at all. And also, I will deal with only two issues in this regard. The defendant
related to security cost, not related to the merits of the case.
No, it is only to prove that the claimant's claim is certain or almost certain to succeed, as per RDC 25.110, that listed as prospect of succeeding as one of the factors should be considered while disposing of an application for security for costs. The defendant has expressed that and relied on an email stating that Mr. Asif is telling a third party, and I focus on this issue, that he left Suresh, not Frontline, Suresh company, or Suresh business, something like that. Suresh's company. Your Honor, we have the pleasure to explain that email, but we think that that explanation would involve us in a detailed investigation, and it is self-evident as long as the board resolution and the email of Suresh are dated September 2013 and dated March 2014, which both of them are dated after the date of the alleged email, 3rd of July 2013, it is enough to prove that that email shall not stand as an evidence, because other evidences on later dated dates has conclusively proved something otherwise.
In conclusion,
Yes.
are you coming to the authority, or that's
We are checking. What I heard only for the authority, Your Honor.
because you discussed the time? That's why.
Why I asked for that authority, that that I heard from the defendant's legal representative while reading that authority, that if such a transfer of assets happened on an earlier date
Before the proceeding.
before the proceedings, that should not be regarded, should not be taken into account. So it is our confirmation that the transfer of the property to his wife happened on March 2015, not only before the proceedings, but also before the alleged termination, before the dispute has occurred.
But again, your client has an asset here in UAE or not?
It is what we have. The claimant owns in UAE.
Only
is
Lexus?
what?
Only car? Which you
The vehicle and the bank account and his family owns substantial assets, which, if it is necessary, we can transfer to the claimant's name if something like that is requested to prove habitual resident. But we believe that
under his name, nothing.
under his name, nothing. For real estate assets, no, it is under within the UAE. But in India and USA, there is substantial assets which have been listed down in our evidence and answer and verified by a statement of truth of the claimant himself.
Okay.
After considering the prospect of succeeding of the main claim, I turn to the delay happened in filing such an application for security for costs. As we believe that RDC 25.107 proceeds by providing that delay to the prejudice of the other party or the administration of justice will probably cause the application to fail. And that delay, which is meant on this RDC, it is it is clarified here that first applications for security for costs should not be made later than at the case management conference, and in any event, any application should not be left until close to the trial date. Your Honor, this application has been filed after the date of the case management conference and at the due date of providing the standard production of document. And we are now about less than 3 months from the trial date. So we believe that the delay occurred in filing such an application is actually constitutes a prejudice to the claimant and the administration of justice. We have almost now completed the production of document stage. The parties are about or are due to submit their witness statements on 18 March. So we do not believe that such security should be granted in light of the delay of filing the application. And it doesn't alter this fact. What the defendant state in his chronology, that due to some elections in Mozambique that caused some delay in obtaining a witness statement of his legal expert in Mozambique. I invite you, Your Honor, to read the chronologies submitted by the defendant on paragraph 6. It is stated in paragraph 6 of the chronologies that the defendant secured a statement in support of the application from its legal expert in Mozambique towards the end of November and finalizing the same in early December. Any delay in securing the statement was caused by the severe disruption to normal business and services as a result of the Mozambican elections in the weeks running up to 15 November 2014. I have 3 issues which can easily dispose of this allegation. The first one, that the defendant was entitled to file the application and supplement his application bundle by such a statement. The second thing, that we don't accept the allegation that there is a relationship between elections in Mozambique and law firms in Mozambique, unless otherwise clearly proved. The third thing, that it seems that the defendant missed the point, that he alleged that the claimant lost his habitual residence within the UAE since 30 June 2013. So when the claimant filed, as per the defendant's allegation, filed his claim on May 2014, he was aware that he is not a habitual resident of UAE. So a delay which we believe cannot be justified warrant this application to fail. Third thing, or third factor that we believe should be considered is the defendant's failure to address the practical difficulties, if any, of enforcing an order for costs against the claimant. The defendant actually, what he did, that they totally ignored the claimant's citizenship within USA and the claimant's residence, as said before, since 2006 in India, and the focus on a recent residence aroused based on an arrangement with his ex-employer, which is the defendant in Mozambique. While we stated clearly in our evidence in answer that the claimant owns substantial assets in USA and in India. So we refer you, Your Honor, to Rafid al-Khurafi versus Ban Barcian, Court of Appeal, in case 1 of 2010, in which it was held that
You have a page reference.
In which page are you asking?
Because I need to know.
in which one?
In which tab?
No. It is in al-Khurafi.
Yes, I have the judgment.
Yes.
He refers to his skeleton argument.
It is mentioned in our skeleton 29, paragraph 29, of skeleton argument, not of the judgment.
Oh, right.
And I have the judgment. But I think I clearly mentioned the rule that I referred to. It is mentioned that it is for defendant as applicant to adduce evidence of the place of residence of the claimant, the place where his assets are located.
Actually, this case is talking about enforcing our judgment in Kuwait.
Yes, that's correct. The place where his assets are located and of any practical difficulties of enforcing against him any future orders for costs. The judgment proceeded further to state that the claimant may then adduce evidence to the contrary. The burden of establishing facts sufficient to justify an order for security for costs rests on the applicant. If on the whole of the evidence the court is not persuaded that the burden has been discharged, no order can be made. So we believe that difficulty enforcement should be proved and should have been proved by the defendant regarding enforcement of cost order in USA and at least in India as well, because they have the burden of proof to prove that. And we stated clearly that the claimant owns assets, especially in USA, which we believe that it is a well-established legal regime which can and easily enforce cost order. But anyhow, we don't have the burden of proof to reply. We don't have the burden of proof to reply unless they prove the difficulty enforcement, which they totally skipped and ignored.
Do you think we need to adjourn and continue after lunchtime? Because now it's 10 minutes to 1 o'clock.
Okay.
Almost finished?
I'm agreeing. I will
Agree with what?
to take a lunch. To take a lunch break.
And after that we can continue?
No problem. That's okay.
I don't get your point.
Yes.
You're going to continue after lunch break,
Yes.
or you
I
have
will
5 minutes
continue.
to finish?
I will continue after lunch break. It will take like 15, 20 minutes.
Okay, 15, 20 minutes we can wait. We can continue.
Okay.
But I think that the most important point here,
Yes.
does your client has an asset in UAE or not? This is my question. And you answer it no.
Has
Asset.
assets? Yes. No. Real estate assets? No. Unless otherwise.
Except one vehicle under his name.
And the bank account.
Okay. You want to add more? You have 5 minutes to conclude your submission.
Okay, I will just quickly refer to other factors after the issue of delay, after the issue of failure to produce practical difficulties of enforcing cost order in the United States of America and India. I'll turn to the defendants. To the claimant's previous conduct and defendant's conduct concerning period cost order. The issue is that I invite you, Your Honor, to review tab 8, page 80 till 86, which expresses the order of Justice Roger Giles. In such order, wrote Justice Giles ordered the claimant to pay the costs as of a specific date to the defendant. And on the first letter of demand from the defendant, the claimant has approved what they offered and settled properly. On the other hand, Mrs. Project Development Engineering Limited, PDL, which is admitted by the defendant as a part of the defendant's group of companies, has and continues to be in breach of 2 Mozambican court orders to pay 2/3 of the justice fees as detailed in paragraph 5 to 6 and 12 of Dr. Maximo witness statements. Dr. Maximo's statement can be found on tab 11, page 244.
Yeah, I'm aware of this.
Yes, okay, that's good. The other factor, the next factor, is the claimant's offer to provide security by way of undertaking. By a letter dated 23rd December 2014 and another letter dated 16 February 2015, the claimant has offered to provide security by way of undertaking to dispose of this application. It is our submission that it is not unusual to provide security by way of undertaking, and even one of the common ways in this regard. And the claimant's reference that undertaking is submitted by non-party to the present case, we believe that as we offer, the undertaking should be made into court, and based on which a consent order to be issued by the registry based on such undertaking and approval of the claimant's spouse, and accordingly that should save the claimant, the defendants, any cost or any litigation to initiate enforcement against the claimant's spouse. I refer here to RDC 45.7.
RDC?
Yes.
Which part?
45.7.
Which is enforcement.
Yes.
Section.
Yes.
And still we don't reach that stage.
And still?
We don't reach that stage for enforcement. Yeah, go ahead.
Yes. That 45.7 states that if a judgment or order is given or made in favor of or against a person who is not a party to proceedings, it may be enforced by or against that person by the same methods as if he were a party.
But at the beginning, you have to mechanism to issue that order.
Yes.
Can you take me to that, any authority, any RDC?
I don't think so that I can refer to you right now, any authority in this regard, but we believe that a consent order issued by a registry with the liberty to apply.
But one of the consent order is not a part of the part of the case. How the registry issue an order without any authority, like you refer me to the article 45.7.
Yes.
But still you don't refer me how to establish at the beginning that order. You refer me to the enforcement.
To the enforcement, yes.
Still.
That it can be a judgment or order is given or made against a person who is not a party.
Okay, how the court will issue that order or judgment? Based on what?
That both of them to be jointly responsible for the costs. Simply as like that, by that undertaking, which is submitted and made into court, and based on which a consent order is proposed.
No comment to say. Okay, continue.
Okay. The claimant referred us to RDC 25.103.
103?
Yes, RDC 25.103. 26.103 regarding security for costs other than from the claimant. That RDC states that the defendant may seek an order against someone other than the claimant, and the court may make an order for security for costs against that person if it is satisfied. The first one, the second one or more of the conditions in Rule 25.104 applies. We believe that this RDC totally does not apply to our case. It is for the defendant itself, not for the claimant, to seek an order against someone other than the claimant. We are not inviting the defendant to seek an order against the claimant's spouse because none of the conditions in 25.104 applies. We are offering, the claimant himself are offering an undertaking letter from his spouse, and if the claimant, it is the defendant's motion to decide whether he will proceed with RDC to seek an order against someone other than the claimant. It doesn't totally apply, as we believe, to the matter of providing security by way of undertaking. I'm almost finished. And in conclusion, the claimant believes that he is a habitual resident of the UAE based on many evidences submitted in this regard as previously detailed, and the defendant submitted no evidence to prove that, especially after securing the business of restaurant trading, the claimant is not under a habitual residence of UAE, within the UAE. This is first one. And the claimant is ready to provide whatever undertakings or statements, as we just proposed in the skeleton argument, that the claimant is ready to submit a monthly statement on a regular basis, accompanied with his future passport exit and entry stamps, for purposes of proving.
And this,
yes.
Can I say as a counter offer to the offer which you asking for at the beginning?
Yes, I mean, just remind me, Your Honor, of what that offer was.
Because before the today hearing, there is steps have been taken by both of you to reach a settlement.
Yes.
And you said there's no counter offer. What I'm saying now is this is a counter. Can I consider this is a counter offer to provide a monthly statement of income?
That doesn't in any way protect us in a way that enables us to satisfy or recover our costs in due course. Provision of information doesn't assist us at all. If, on the other hand, the claimant were to offer 200,000 by way of payment to the court, that would be suitable.
We'll come to that point. Yes, go ahead, Mr.
Yes. As a statement and a proposal has been made in the skeleton argument that the claimant can provide a monthly statement on a regular basis for his future passport stamps for exit and entry within the UAE in order to prove his habitual stay and residence within the UAE, and especially after the start of his new employment. So, moving quickly over the circumstances of this case, I address only the conclusion that on August 2014, only the residence visa of the claimant has been cancelled, and it is common to take 2-3 months in order to secure a new opportunity, especially that you have an ongoing litigation in Mozambique against subsidiary of the defendant, especially that the claimant has to do a regular medical check-up on each period of time for based on his medical conditions,
Okay, I'm aware of this statement.
Yes.
Something to add?
Yes.
Something new?
It is only that our submission that this application should fail as none of the conditions of 25.102 applies, and if any, having regard to all circumstances, should fail. And alternatively, if the court believes that a security should be granted, that we are still offering an undertaking from the claimant's spouse, which owns substantial assets as proved, which owns the substantial assets, to pay the cost order of the cost order if being made against the claimant. The claimant also repeat his readiness to submit the statements for his future movements, and if for the reason set out above, the defendant's application issued on 10th December 2014 is to be dismissed with costs awarded to the claimant.
Thank you.
Thank you.
Any offer? I
We-
heard your colleague
Yes.
there is an offer.
Yes. For
Already discussed?
one half minute, please.
Can I just confirm?
Yes. My client is just now offering, if accepted, to provide a security for costs as against the withdrawal of this application, as for 100,000 US dollar, 50,000 US dollar to be paid now, and 50,000 US dollar to be paid on 13 March 2015.
Which is in court account.
Yes, but on or before 13 March. Of course, the payment will be into the court.
Not to the defendant.
No, of course, into court.
That double check.
I mean, we welcome any payments, but
Yes, I think let's start from where we end.
well, I'm going to be 20 minutes dealing with the numerous misstated facts that my learned friend has made. I simply have to correct them.
Before you deal with that, in principle, are you accepting their offer? In principle, do you think you need to
I would
refer
have
to
to
the...
but more importantly, we have spent something in the region of $39,000 to get to this point. An open offer, if it was going to be made, ought to have been made well in advance of this, and it hasn't been made. So we'd be looking for our costs as well incurred, which is substantial. There's a lot of preparation that's gone into this application.
Do you think if I give you until lunch break and discuss, and we'll adjourn for a lunch break and we'll come back at 2 o'clock,
Very sensible.
will be good for both of you to reach an agreement? I feel there is some, could be.
I will approach any discussions in good faith and with a view to reaching some sort of agreement, but I cannot guarantee it. And if an agreement isn't reached, I would like to continue for 15 minutes.
Fine, no problem. And my order will be end of the session today.
Yes.
Okay? Thank you. We'll come back then at 2.
All rise.
I don't understand why if you're going to make an open offer you didn't make previously. Frankly, the cost that you've spent now because of
You're
Yeah, no, I'm going to leave these here. I don't really need them. Yeah, go, yes, yeah, absolutely. Right. Sorry, just one second.
Yes. I see that. But you no.
Where will you be? Will you be here?
Yeah, we'll
Yes,
be.
yes,
No, it's alright. We'll be here.
You're not going to leave?
Okay. No, I'll just go for a smoke.
But I need a minute before.
Yeah, I'm just going to.
Just-
speak to me.
Yes.
Okay. Have you got my mobile number? Because I'm just going to grab a quick sandwich. You know, I'll just write. Shall I just write it down for you?
If you don't mind, please. So we granted up to 2 p.m.
Yeah. Okay.
So I believe 1:45 is suitable.
I'll come
We
back.
will reach
Whenever,
the-
I'm just going to be in the office, which you know is just upstairs. So
Yes.
if you've got
Great.
some kind of offer to make,
I think I have.
right, I'll just go.
Just,
just call me and I'll come back.
yeah.